Hello, this is Dr. Tom Groover from Boulder, Colorado. I'm a member of the Colorado Community Rights Network and the National Community Rights Network, and I'm here today with the Executive Director of the Community Environmental Legal Defense Fund and co-founder of the Democracy School. Also, he was ranked by Forbes magazine as one of the top 10 revolutionaries of our time, Thomas Linzey. Thanks, Thomas. Really appreciate your being here.
Yeah, thanks for having me.
And the reason I wanted to talk to you on camera in this little grassroots, show, so to speak, is that we're having a crisis here, and we see that this crisis is spreading throughout the country in many different forms. And in our form, it's the fracking industry, the oil and gas industry, that wants to move into our communities and frack next to our homes and our schools and our nursing homes and our hospitals and you name it. They want to be there. And the issue here is that we've had local communities who have banned or put moratoriums on this fracking process, and these have been preempted. They've been nullified by the Supreme Court here in Colorado, and so now communities are all realizing that that's a precedent, and they're getting ready to frack everybody even more so. And so just right out east of here a little ways and north, we have 30,000 fracking wells already. Now they want to put 1,800 wells between Interstate 25 and 76th Street here in the Boulder County area. And it's overwhelming.
Yep.
And most of us moved here because Boulder is heaven on earth. It has a reputation for, being very concerned about the environment and very concerned about social justice and this history of the Republic of Boulder, so to speak, which is a kind of a farce that we find, because right now our county commissioners are working toward accommodating that the oil and gas development plan.
Yeah.
And so we're concerned, and based on most of our backgrounds, we're all thinking, well, what went wrong?
Mm-hmm. And I think in many ways the question is not what went wrong for us, but what has gone right consistently for the oil and gas trade associations and the oil and gas corporations themselves. And here in Boulder, the issue is fracking across the United States. It's corporate water withdrawals, it's dewatering aquifers, it's toxic waste landfills, it's genetically modified seeds coming into communities. Any of 100 different single issues that you can think of are affecting communities across the United States. And unfortunately, some people still believe that the law is neutral, that the system of law that we have in the United States is neutral, that judges are neutral and courts are neutral and legislatures are neutral and governors are neutral. I think some of that, people have been disabused of some of that here in Colorado. Governor Hickenlooper coming in on the side of the oil and gas associations to sue the municipalities. Doesn't get much clearer than that. But I think what's under the water, and some of this stuff is like an iceberg, where you see the top 20% that's sticking out of the water, but 80% of it is under the water and you can't see it.
Right.
That most folks don't see that 80%, which is the fact that for the past 200 years, there's been a structural bias built into the system of law in the United States, that when you look at scales, not just a thumb on the scale, but a fist down on one side. So if you have communities on one side who are saying, hey, we should have the power to stop that which threatens to harm us and our families. And on the other side, you have the corporations that are trying to extract or trying to do any of these other projects, who actually, their fist is down on the other side. That the structure of law that we have in the United States not only favors those interests, but actually mandates that those interests be met, be satisfied. So if you're a corporation interested in extracting resources, oil and gas from a community, you have more rights under our system of law than the community has to stop you. Right. And that comes as a surprise to a lot of people who say, well, isn't our system neutral? And don't we live in a democracy? So if enough people in the community come together and say, we don't want this thing, don't they have the legal authority to get it? And the answer is no. If you ask that question to 99% of the people out there in Boulder or elsewhere, people would say, that's crazy. Of course we have the power to do X, Y, and Z, and of course we have the authority to do it if enough of us come together to do it. And therein lies a crisis of its own, because you have people that don't understand the system in which they live.
Right.
They have no clue how the system operates. So when Fort Collins and Longmont and Lafayette, when those communities of people move forward to actually say, hey, wait a minute, either we want a timeout, moratorium, or we want a ban of oil and gas for fracking within our community itself, that they're surprised when a court rules against them.
Right.
And says, well, this is preempted by state law that says you can't do it. But it's 100% predictable that that's going to happen. So what's driven us up the wall for the past 10 years is that people in this system, in our society, in the United States, don't understand how the system of law has been constructed. And if they understood how it had been constructed, and not have to get into each of these individual fights to prove to themselves how the system is constructed, we would be much further along in understanding that we need a complete overhaul of the system that we have. It's not just wealthy buying access to the system, which some people say, oh, we don't have a democracy because wealthy buy access to the system. That's the ninth inning. The corporate boys have constructed it so they win the game in the first inning.
Right.
So the influence part is all the way down the line, but they have a constitutional structure in the United States, whether it's a state constitution or federal constitution, that actually mandates that resource extraction take place.
Right.
We always think about preemption as being a definer. You can or can't do certain things in the community, but it's more than that. It's actually a proactive requirement that fracking take place in a community. It's not just saying, hey, people in X, Y, and Z community, you can't do X. That's one thing. That's a limitation on them taking action. But when the legislature passes an oil and gas act that strips power away from the community to stop oil and gas extraction, they are mandating that oil and gas extraction take place in that community. It's not just a limitation on the municipality. It's actually a mandate. It's forcing that use into an unwilling community. And so I think a lot of people are surprised when this stuff happens, but it's completely predictable. If you understand how the system operates, you can set different variables in play. And it's like Madden football, where they predict the Super Bowl each year, and they come very close. They have the computer system set up where they plug in the variables and then they just let it run. If you understand how the system is set up, you can plug in different variables about communities saying no or moratorium or whatever, and pit that against the corporate power that exists today institutionally within the constitutional structure and the law. And you can predict how it's going to come out. It's no surprise.
Right.
But people don't understand how the system works. And that's why our activism is so stunted. Because people go into this saying, well, the problem is we just haven't said no yet, right? All we have to do is say no and everything will be okay. Instead of framing the problem as the system doesn't allow us to say no. Because if you say to yourselves, the problem is we haven't said no yet, simple, all we have to do is say no. Let's use our initiative power to say no. Let's do that. And then you get creamed because the system creams you, it punishes you for doing what you've done. But if you frame the problem as we don't have the authority to say no, because we don't live in a democratic system, then the solution becomes something much different. You become much more advanced in your organizing. It's almost like not knowing what the army on the other side looks like. And you think to yourself, all we have to do is pick up a couple guns and just walk out there and everything's going to be fine. But you have to understand the true scope of how the system works. And that's been our disappointment over the years, because the environmental groups, the large environmental groups, stopped thinking about this stuff 30 years ago.
Right.
They just stopped thinking. They don't think anymore. There's no strategy, tactics outside of the existing stuff. And of course, when you grab onto the existing stuff, whether that's permit appeals or in fact using initiatives to do moratorium or limit or regulate or whatever, you run into that same buzzsaw. So those large environmental groups, I think, have become as big a problem as some of the corporations that are trying to extract oil and gas, because people turn to environmental groups as their allies, yet their allies are selling them out every day. And so we're in a system where a new identity has to arise. You have to find people who are willing to engage in a new understanding of the system that we're stuck in. Otherwise, we're just playing games. It's like putting on a play. Let's put on a play and go through the steps. But let's not be honest with people about the system that they live in because we think it's too horrifying. But the fact is we have to come to grips with that and do new work. That's why the work of the Colorado Community Rights Network in this state is so important, because it's actually people who are getting their heads out of their asses to understand exactly what the problem is and then begin to dismantle the system that we have.
Right. So we have a community rights amendment, as you know, because you helped write it. And it's an amendment to the Colorado Constitution. And it's really directed at legalizing the practice of local community self-government so that communities can define their inalienable rights as they see them and prohibit things that violate those rights.
And not be punished for it.
Not be punished for it, not have the state, hire a judge to preempt us.
Yes. And if you're in a community and you think that the problem is just that we haven't said no to bad things yet, there's no need for the constitutional amendment. I mean, because if you think the problem is just that we haven't moved forward to vote to ban something in the community, and you think that's the problem, then your energy is going to be spent on how do we put a campaign together to say no to X.
Right.
But it's not about seeing the train, the light at the end of the tunnel is an oncoming train kind of thing. So
right.
Unless you look down and understand what's coming, you can't really frame a solution because you frame the problem the wrong way. But if you're like the folks in the community rights networks across the United States, you know the train is coming, you know the train is there, you know who built the train, you know who built the tunnel. Right. So the question is, how do you avoid getting creamed? Yeah. And if you pose the problem that way, if you frame the problem the correct way, then the Colorado Constitutional Amendment begins to remedy what's wrong. And what's wrong is we have a system of law that's not going to deliver the change that we need to have happen here to survive. If you're talking about 20,000 frack wells, it doesn't matter how you frack. It's like, you can build fences around the frack wells and send it through the sewage treatment plants, public water treatment plants, the waste water that comes out. You can do all that stuff. You can try to frack environmentally, which is where a lot of the environmental groups are. But even if you frack environmentally, what you're taking out of the ground is automatically being combusted. Or the release of methane, which now the science is telling us is extraordinarily bad for the climate, even more than combusting fossil fuels. That legally, even if you do it environmentally, even if it's safe from an environmental standpoint, even if assuming you could make it that, which I don't believe you can anyway, but even if you could, you're still combusting the fuel, right, which is cooking this place. It's cooking this planet. And it's like just recently a train derailed in Mosier, Oregon, out near us, out near Spokane, Washington. And, the first thing that happened was people said, oh my God, this oil train, it ran off the tracks. It was derailed and went off, crashed, and leaked into the Columbia River. And everybody was like, oh my God, it crashed. We got to do something about this. 100% chance that it would happen anyway, because you're running oil through tracks. Of course something's going to derail. So people say we got to say no to these things. And immediately, the system is so pervasive that it just kicked in so that all the important people, the newspaper reporters and the editors and the lawyers and the law professors said, well, you can't regulate commerce on the rails. You can't say no to fossil fuels coming through your communities. To which then the community shifted automatically and said, well, what we're about is safer rail travel. We just want to make it safer. Right. Without understanding, or perhaps understanding but not being willing to grapple with it, that oil being combusted is the biggest public safety issue of them all. Right. Individual trains are a big issue blowing up, sure. But even when used legally, what they're carrying is a legal substance that if used for its intended purpose is to combust. And if it's combusted, then it's cooking the planet. The problem is climate change. It's not safety of the rail cars. That's like secondary. The fact is it's climate change. So anyway, the reason why I bring this up is that the system controls how we think. Yes. It enters our brains. It censors what we do from an activism standpoint. Because we say, oh, can't touch the trains. Okay, well that means we're going to have to beg and plead the federal agency that has control over the railways to do something to make the rail cars more safe. And that's a completely different thing that frames the problem a different way and doesn't get us to the need for communities, for example, to stand up and say no to fossil fuels being transported through our communities. It's all about how we frame the problem and more people understanding that's a very complex problem that a lot of people don't understand, and it means coming to grips with the fact that we don't have a democracy in this country.
So now this framing of the problem, we saw how we did that here in Colorado with the Lafayette Community Bill of Rights to ban fracking, because we needed to have some kind of legal protection. You know, we thought we could do the initiative process and ban fracking, because we didn't think that it could be done safely.
Right.
All right. So then what we did was we worked with your firm and you, and you know, we came up with a pretty impressive list of inalienable rights for the community, like the rights to clean air, clean water, freedom from chemical trespass, the right to peaceful enjoyment of home, the right to for the environment to exist and flourish, and also the right to enforce, you know, a ban on industrial processes that violate those rights.
Yes.
And yeah, and it passed by, you know, 62% of the people, you know, so it was adopted as law. A month later, we get sued.
Yep.
And then we went through a bunch of court, you know, battle,
Yep.
lots of brilliant briefs. And our argument was that the Colorado Oil and Gas Act and the governor and the Colorado Oil and Gas Association, everybody there violating Lafayette's inalienable right to local community self-government.
Yeah.
So that was our way of understanding the situation, of actually framing the problem.
Right. Unfortunately, well, a couple points there. Number one, what Lafayette did was magical. I mean, close to 200 other communities have done the same thing.
Right.
Which is basically people sat down and said, we're not interested in safe fracking for the reasons that we've covered today. We want to do a ban. Okay. And when you say we want to do a ban, you begin to understand that the system doesn't allow you to do a ban.
Right.
Because the state permits fracking, and fracking is a legal activity in Colorado. So communities are banned from prohibiting fracking.
But we want to do it anyway.
That's right, we want to do it anyway. So if you know that a ban is the only solution to the problem that you framed, and you know that you're confronting a system of law at that point that doesn't allow you to do it, then you become smart and advanced about what you're trying to do enough
Right.
to fashion a tool, a legal tool, in this case a law, that actually begins to ask, begin to ask yourselves, if we want to ban this because we understand a ban is necessary here, what rights of ours are being violated by fracking in our community? How do we write the ordinance in the best way so we know that the train coming down the track, we're in the best defensive position to try to fend it off?
Yes.
So the ordinances themselves, like the Lafayette Initiative, contain a Bill of Rights. The people of this community have certain rights to clean air and clean water, sustainable energy future, those types of things. Then they ban the activity as a violation of those rights. So it's not just a ban. It's not just a one paragraph thing that says we're banning X. It ties it to rights,
Yes.
which automatically puts you in a position of arguing that communities should have the ability to expand rights out. So just because you don't have these rights in the state or federal constitutional framework, that you should have the ability to expand rights out at the local level. Which, surprisingly, is not such a radical idea, because the state and federal governments have been doing that for the last 60 years,
Right.
which is that the federal courts recognize, and courts in general recognize, that state governments can expand rights out, constitutional rights out, beyond the federal floor that's provided. So if you want people in the state of Colorado to have rights, like it's not that popular among certain circles, but the Taxpayer Bill of Rights, the Tabor stuff, which has a lot of problems.
Yeah.
But it's an expansion of rights. And generally the courts have said this to the state governments, you can expand rights beyond the floor provided by the Federal Bill of Rights. What we're talking about is extending that relationship down to the local, because right now communities aren't recognized as having any of that kind of authority. So you tie it to rights, you ban those activities that violate the rights, and then knowing that the train is inevitably coming down the track,
Right.
and you know what mechanical items on the train are going to hit you first,
Right.
you know how to fashion the law to actually begin to challenge those doctrines directly.
Yes.
So in Lafayette, nullified preemption. It said preemption for certain purposes will not be recognized within this community. So if the state says we can't, we're saying the state has no power to do that.
Right.
We're saying the state is acting unconstitutionally. We also know that corporate rights are a tool that can be used. So in Colorado, preemption is so powerful, the corporations don't bother using corporate rights because they can use the preemptive power of the Oil and Gas Act to do what they need to do. But corporate constitutional rights, like personhood rights, have been used in the past by corporations to sue communities. So knowing that train is coming down the track, then nullifying corporate rights and saying corporate rights are unconstitutional as well. It's a violation of our rights for corporations to have rights to override this law. So all that is well and good. And those types of laws have been passed both by elected officials in the United States as well as by initiative in different places, close to 200 now in 10 states. And the problem we get into is that the fight that gets picked, and make no mistake, these laws are about picking a fight, because they understand that it doesn't matter whether we want to ban in our community. We have to change the system that says we can't ban. So we actually have to challenge that structural stuff before we can do the ban. We have to change other things before we put the ban in place. That when the corporations come in, or in Colorado, the Colorado Oil and Gas Association, so COGA, when they come in to sue the municipality, they don't sue you. They don't sue the people of Lafayette. They don't sue the community, the people themselves.
The people that actually enacted the Bill of Rights.
Correct. They sue the municipal corporation.
Right.
So your municipality, Lafayette, when we're talking about the city itself, is a municipal corporation.
Yes.
So they're a corporation themselves. Boulder is a municipal corporation separate and apart from the people who live in Boulder.
Right.
You're not really seen under the law as a resident or a citizen of Boulder. The only thing the law sees is your municipal corporation. In the eyes of the law, that's all that's seen, is the municipality and the state and then the federal. But the municipality is a corporation. Boulder is a corporation. And the corporation has interests separate from the people of the community. So if the people of the community pass something that the municipal corporation disagrees with, the municipal corporation has the ability through different tools to override actually what the people have voted to put into place.
Right.
To a lot of people that makes no sense, or it's shocking. Because in our constitutions it says people are the source of all governing authority.
Right.
And the highest authority in Boulder is supposed to be a majority of the people that live here. But that's not how it plays out. How it plays out is COGA sues, in this case Lafayette, which is the municipal corporation.
Right.
The people are left in the cold. The people that did the petitioning, that wrote the ordinance, that qualified the ordinance, that voted for the ordinance, at that point are taken out of the picture.
Yes.
Because the only thing the court sees is COGA and the municipal corporation itself. And the municipal corporation, sitting on the board of directors of the municipal corporation, are your elected officials. They're seen as essentially board members of that corporation. So they're sued. If they don't like the ordinance, they don't like the initiative that was passed, they have a variety of different ways to settle the case. They go to the corporation and say, hey, we'll agree not to enforce this ordinance, or we'll agree not to fund enforcement of the ordinance. So there are various ways that they can sign a settlement agreement to actually void out what the people of the community have adopted.
Right.
And again, sounds anti-democratic, but it's the way the system operates.
But it is.
It is. And it gets worse because those elected officials have a lawyer, the lawyer that's representing them in the lawsuit. Any communication between the lawyer and the municipal officials is subject to attorney-client privilege. So the people of the community, who again were the ones that actually passed the law, are cut out because the attorney-client privilege is secret. It's privilege. It's communications between the lawyer and the municipal corporation do not permeate outside of that communication, that relationship. So people in the community have no clue what's happening with their own lawsuit. They don't know if the municipality is settling it out. They don't know if they're signing something to agree not to enforce. And worse yet, even when the municipality decides to fight, being on the defensive, fight for the law, the legal defense of the initiative, the legal defense of the law, never mirrors what the law itself is. Because the people in the community put in a pretty radical thing, which says we have a right to local community self-government, we have a right to make this law, preemption is unconstitutional, and corporate rights are unconstitutional, right, in a nutshell.
Right.
The municipal corporation has a conventional, traditional lawyer that's representing the municipality, and their arguments are all about trying to find a gap or an exception to preemption or corporate rights to argue to the judge that somehow we found a loophole in all of this. It's what municipalities have been doing for 40 years, which is trying to find loopholes and exemptions and all this kind of stuff. But what they don't argue is a frontal challenge to say this action by COGA is unconstitutional. It violates our right of self-government. We're asking the court to recognize a right of self-government, and corporate rights and preemption are unconstitutional in the scheme of things. That argument never gets made.
Right.
The court is never put in a position where they have to rule on it, and it's not embedded as an appealable issue because the Municipal Corporation has not argued it. In those cases, we've attempted to help groups, the community itself, who should be there in the first place, intervene in the lawsuit.
Right.
So actually come in as a party and actually participate in the litigation to make decisions and have a lawyer and brief the case and all that kind of things. Unfortunately, the trend in the United States recently has been to deny intervention.
Right.
So to deny the community even having a voice in the litigation itself. And so what happens is, no surprise, the thing is like a snowball that just goes downhill, because once the municipality decides, A, they're going to enforce it, but B, they're going to do so conventionally in a traditional sense, you can predict that it's going to lose. Because that's what we've been arguing for the past 50 years, is somehow there's a preemption loophole or an exemption or something. So they go ahead and argue it, they lose the case, and you get what you've gotten here in Colorado, which is something that's 100% predictable that it would happen. And folks at the beginning, if they understand that the system of law is set up a certain way, then that ordinance that they've adopted, that Bill of Rights, becomes a stepping stone to something else. I, for one, don't think that the Colorado constitutional amendment that's being proposed now would have been proposed without the Lafayette initiative.
Absolutely not.
Yeah.
When we wrote that amendment with your help, it was a way of what we thought was defending the Lafayette Community Bill of Rights and setting a trend for other communities in Colorado so they could do the same.
Yeah, trying to make it stick.
Yeah.
Yep.
And we thought it was a defensive maneuver, but now we realize that basically it's offensive. It's an enforcement maneuver. It opens up the rationale for enforcement. And,
Yes.
when I read the briefs that came from us, we the people, with your help and with help of Libby, our lawyer, and I don't know, you must have had a whole team of people helping us.
We do.
Nationwide. Yep. But I mean, it was a brilliant argument. It went through the whole history of self-government in this country and the constitutional right for that to take place, and on and on and on. It blew me out of the water, and as far as I know, nobody ever even read it but me, and the ones that wrote it. I mean, it certainly didn't show up in court.
Right.
They don't argue that. They don't even want to hear it. All they want to talk about is who has the right,
local versus the state,
to determine what goes on in your local neighborhood.
Yeah.
And they're saying not the people that live there.
Right. So you have a small number of people outside of the community rights movement stuff who are now coming to some of those same conclusions, that we have a problem with the system. It's not a problem with what we do individually. It's a problem that doesn't matter what we do individually, that the system stops it.
Right.
And so then those folks have said, well, the answer is to carve out space for communities to ban fracking. In other words, tie it to the single issue, that if fracking is the big issue, that's the issue, then we should write something very narrow that says that communities have the power to regulate or ban oil and gas extraction and fracking within their community, and leave it at that, make that a constitutional amendment. The problem with that is that why in the world would you go so narrow so that your constituent base is so small?
Right.
In other words, it's only people that care about fracking and oil and gas extraction. Meanwhile, whether it's cyanide, there's a big fight here about cyanide being used for mining, have been preempted. Yeah. Whether it's water withdrawals or factory farms, communities not being able to say no to all these things. Why in the world would you put a proposal forward that's only supported by a very narrow constituency? Why not pick up all of them? Because I got news, the fracking constituency is too small to actually take on and win against COGA and these other entities. It's just too small. It's just because not enough people care about fracking. A lot of people think fracking is a good thing. But when it comes down to a question of local democratic authority, and there's a pattern, because a lot of what we do is just showing people that there are patterns out there, pattern recognition, so people can see that it's a plan. It's not just a judge, and just not a bad elected official. It's not just a bad decision. It's not just a bad appeal, appellate decision or whatever. That it's a pattern. And so why wouldn't you, Lord of the Rings, the battle was to take on the big guy, the Dark Lord. So they had to take the dwarves and the elves and the ents and the hobbits and the wizards and everybody else. Why would you just have the elves take on the guy, right? Why Why would you do that? It's just a bad strategy and bad tactics. I mean, after you've arrived at a point where you say the problem is the system, we have to carve stuff out for ourselves so we can move forward with stuff that we want. Why not bring everybody together?
Right.
Because for the past 40 years, we've been so ineffective because we have siloed ourselves. You go to environmental conferences, the timber activists are over in this room, and the water activists are over here. We do it ourselves. We censor and fragment. And when we fragment, that's what the other side loves, because we're apart. But the fact is, it doesn't matter what we want. In this room with the timber folks, it doesn't matter what you want for sustainable forestry or protection of old growth, because we can't get it within our communities. It doesn't matter what we pass.
Right.
It doesn't matter what we want.
Yeah.
So until that happens and people join hands and say, we understand our single issue is connected to everything, the entire universe, the constellation of options out there for communities, and come together and say we're going to move a cohesive, collaborative platform. That's what the boys are afraid of. That's what they're terrified of. They're terrified of all these different folks coming together and finally saying, look, the answer to this is to carve out for all of us so that we can recognize our rights, whether it's with water withdrawals or factory farm or fracking, to bring all those people together to then move forward and say we're going to change the system big time, because we're going to carve out the space for our communities to have the legal authority to ban those things that are harming us within our communities. Until that happens, it makes no sense to me that people run strategies that try to be as narrow as possible, almost to be as non-controversial as possible, or to be as, to not peeve enough people, people off who may be resistant to a bigger picture thing. But that's just dumb. It's dumb from a strategy perspective. It's dumb from a tactical perspective, that once you get to that point of understanding that the system needs to be changed, why wouldn't you join hands with everybody who wants to change it and make it bigger than just one single issue? That seems to me just ultimate stupidity. I mean, the other side's laughing when we do that.
So you're here doing a tour, and the title of the tour is Time for a Colorado Revolt. And last night, for instance, I got the report that there were 70 people at your talk in Denver. And the organizers there reported that the people there were not that interested in the fracking issue in the state. They were more interested in the fact that any attempts to create a local minimum wage greater than the $8.30 or whatever it is the state mandates is illegal. It's preempted by the state.
Yeah.
That was one thing, and also that the state preempts any attempts to create local rent control laws.
Correct.
So those were their big issues.
Yep.
And it makes totally sense. It's a big city. Here in Boulder, we're concerned about what's coming over the horizon.
Yep.
It's like there's an invasion coming over there. You can hear the tanks rumbling,
Yep.
What are we going to do? And so what we have now is a state amendment that is a strategy to enforce, really. It's one of our strategies to enforce. We have also considered the fact that we have the state amendment will then nullify preemption and also approach those other issues of corporate rights and corporate quote rights and corporate power and Dillon's rule, which is sort of the father of preemption and things like that. And incidentally, if you're interested in these legal doctrines and more advanced, catch up on some of the more advanced terminology, contact us and we'll put you on our enrollment list for our next democracy school that we hold here regularly. That's put on by the Community Environmental Legal Defense Fund. Okay, so sorry, I diverted, but the point I want to make is that we have a state constitutional amendment drive that's going on right now. We're petitioning. There are a lot of people out in the hot sun all day long doing this. People on the weekends are doing this, giving up a lot of their free time. We're very passionate about this. And the pressure is incredible for this to happen because the state is now trying to raise the bar on initiatives.
Shocking.
So that we need to make it even harder. We have to get over 100,000 signatures right now to be able to amend, even put the issue on the ballot for people to vote on whether they want to amend the Constitution to legalize the right to local community self-government without fear of state preemption. All right. So that's the reality here, and we have this, what we feel is a crisis. We have an urgent need.
Yep.
And it's kind of like we've touched upon what I would consider actually the single issue. When we talk about single issue environmentalism, we're talking about this group over here is for the whales, and they're for the wolves, and these people are over here for the water, and these people are for the air, and these people are for the food, and there might be a few people that are interested in human rights and things like that, but it's a division. It's a huge division of resources and a whole division of labor and a whole division of attention, which has us all defeated because of, like you said, if we don't approach that single issue, the right to self-determination, we're screwed. Yeah. So we've got that state amendment going on here, and it's also been going on in Oregon and New Hampshire, and Ohio's getting ready to do it. So we have this foundation now that we're working up through because of the need to defend and to enforce our local community bills of rights, and the reasoning behind that based on rights, that we're thinking now that we need to open up the narrative, the conversation about amending the federal Constitution.
Yes, and I think there are two things to be said in response to what you just said. One is that these local ordinances, the initiatives, the charter amendments, whatever form they take at the local level as people are moving forward to change the system, are essentially civil disobedience.
Yes.
That they are breaking the law. They're using the law to break the law.
Right.
That was a big applause line at the premiere of our movie, the new movie coming out called We the People 2.0 in Seattle. People were like, oh, using the law to break the law. That's a huge thing, because we're used to civil disobedience as being somebody sitting down in front of a bulldozer and, the police coming in and then the criminal justice system crashing down on that person. But a lot of the local lawmaking stuff is about collective civil disobedience. So people coming together saying, we're going to seize our municipality and use it for something that the system never intended it to be used for, and we're going to turn it upwards against the corporation and against the state, which is enabling the corporation to do what it does. So it's a form of civil disobedience. It's a collective form with an understanding that individual acts of civil disobedience, as much as we all have either partaken in them. Now, I've been arrested once for civil disobedience, but or however much we want to partake in them, that they tend to be fairly limited and defensive in scope because we're on the receiving end of the criminal justice system, which has made illegal the types of things that we're doing. So the ordinances and initiatives are a type of civil disobedience. I happen to think that individual civil disobedience, especially in those communities where laws have been preempted, has to go wide scale.
Yes.
So, sit-ins at, 5,000 frac wells or whatever it takes to do that. And as a law firm, we don't defend folks, we don't encourage or advocate. But personally, we're in a situation now where things are so bad that I think any degree of civil disobedience is not only good, but necessary to actually shut the thing down. I mean, in the 60s, they talked about, throwing a wrench in the machine and putting your body on it to actually stop it.
Right.
We're at a point where physically it needs to stop. We have to stop, and anything we can do to make that stop, that has to happen. So putting that to one side, the other side is that on a bigger picture scope, you have the local laws, which are essentially new constitutions for the locality.
Right.
They envision a new system of law. It's a system of law that we don't have today. It envisions a new system.
A system that we actually want.
Yes, they're actually like blueprints.
Yeah.
So
we're going for what we want and we're not fighting against what we don't want.
Yes.
Here.
So in New Hampshire, where you have a dozen communities that have passed these laws, or Pennsylvania, where 100 have passed these laws, they all look different because they're all on different single issues, but a lot of them look the same because they're all about taking on that structural stuff. So preemption, Dillon's rule, corporate rights, those doctrines, they're all about nullifying the doctrines. So those folks have come together to say we need a state constitutional amendment that actually takes apart those doctrines as well. So just like in Colorado, where Lafayette led the way and Colorado is leading the way on the constitutional amendments, people came together and said we need to change the system, this is what we need to do. The there's good parts to that and there are bad parts. The good part is that a lot of it is changeable at the state level. So state preemption, how the Colorado Oil and Gas Act preempts local communities, that's solvable at the state level, which means that your state constitutional amendment can fix that, okay? There's other things that the state constitutional amendment can fix, like Dillon's rule. So in Colorado, your communities are treated as children to the state being the parent. The child can only pass the laws that the state tells them that they can pass, except for purely local affairs, right, which is really an exemption that's meaningless at this point. And so it can change that. You can override preemption, dealing with specific issues. You can override Dillon's rule, and you can override corporate constitutional rights as those are embedded in the state constitution.
Right.
So those three doctrines you can actually get at with the constitutional amendment. So it changes a lot, changes that whole landscape. The problem is, one of the problems is that corporate constitutional rights are federally embedded as well. So you can chase them out of the state. In other words, you can ban or prohibit the state from being an enabler of the corporations that are targeting your communities for these types of projects. And you can do that through the constitutional amendment by amending the Constitution like you've proposed in Colorado. The problem is you have a superseding layer in the United States as well, which is another thing that has to be taken out, where corporate constitutional rights are federalized.
Right.
So corporations are persons within the federal Constitution. You also have the Commerce Clause, which is in the federal Constitution. From a conventional lawyer's perspective, you can't use state constitutional amendments to change the federal government's powers or how those powers are interpreted. And so there's a need to not only move beyond the state constitutional amendments, which in shorthand we talk about chasing the corporations out of the state constitution. That's what the amendments are about. They can run to the federal constitution. We need to chase them to the federal constitution. And so state community rights networks, like in Colorado, have come together to form the National Community Rights Network,
right,
which is a national organization that's focused on, among other things, making that federal constitutional change. I think that federal constitutional change, which has been drafted right now in the form of an amendment, is basically a mirror of the Colorado constitutional amendment, yes, in the form of a federal constitutional amendment to recognize a right of local community self-government that then becomes a federal right.
Yes.
So this is about, what you're doing now is driving in a state constitutional right. This would be about driving in a federal constitutional right. And the reason you have to do that is because you have to chase the corporations out of the federal constitution. And you have to detach them, not only from using state government to do what they want to do, but also detach them from using the federal government from overriding communities. And so that has brought us into a conversation about how wide scale this change needs to be. Are we talking about amendments to the federal constitution? Are we talking about rewriting a new constitution?
Right.
I personally think that we need a new constitution because the one that we have was written in the 1780s. And it was at a time when we didn't have deforestation or ocean acidification or 90% of species in the United States now extinct, or after we've logged 90% of all the forests in the United States. I mean, the numbers are pretty grim across the board. That the thing that was written in the 1780s, my guess is if you sat some of those same people down now and said, okay, we need, knowing the problems that we have, what would be drafted now, would be a completely different document. In the 1780s, the idea was, how does the US become a world power? And the only way to become a world power is to turn natural resources into products that can be exported to build that type of economy in the US. And so they built and constructed a document that essentially allowed for accelerated exploitation of natural resources across the United States. That was the plan.
Right.
And they did it by putting the interests of property and commerce above any other interests or rights. And that's the structural thing. That's the bias we run into when Lafayette tries to do X. It's basically from the top down. It's all constitutionally mandated. That, in many ways, that document has to be replaced. We need a sustainability constitution. We need a new constitution that's written by all of us, because we forget that the Constitution that was written only applied to about 2% of the human population in the United States. So it was only white men with property. Women weren't in the room, African Americans weren't in the room, slaves, of course, weren't in the room. White males without property weren't in the room either. And so they wrote up a governing document that only applied to a very, very small percentage of the hominids, the people on two legs in the United States.
Kind of like the 1%.
Yes. And so from a substantive perspective, the constitutional structure doesn't work anymore.
No.
It doesn't work because it was written for a different purpose. It's not written for today. And if we had a computer program from the 1780s, we would have updated it a zillion times by now. And so the fact is we have a 1.0 governmental system that does not recognize the 4.0 problems that we face today. And so it responds in a medieval fashion, which is to say we're right and you're wrong and we're higher government than you and we're going to override you for the interests of these other folks. And also from a procedural place. So substantive doesn't work anymore because the substance is medieval from the 1780s, but the procedure was not a document that was democratically adopted by anyone. Even the ratifying conventions, you're talking about a couple hundred people in states like Pennsylvania who ratified the Constitution, and they were all white males with property. So we have a document that wasn't developed democratically. And some people say, oh, well, that's not right because we have the amendments and the suffragist amendment and the abolitionists and the 14th. Well, we did, but it took a war, and it took a lot of bloodshed to be spilled. And we forget in the United States that corporations got rights 40 years before women got rights in this country. That the process for changing how the Constitution operates from an amendment perspective is so difficult, hardly ever been exercised. And people who, conservatives who tout the Constitution are like, well, that's great because we wanted to make it so tough that the Constitution couldn't be changed.
It's lasted 200 years.
Well, that's nuts.
It's got to be good.
And it's also why people should ask themselves, why aren't the conservatives the ones calling for a new Constitution? And the answer is they don't need to. It's theirs. It's the one that they want. It's their Constitution.
Right.
That's why they don't talk about rewriting a new one, because the one that's there is theirs. They don't need a new one. We're the ones that need a new one. And so I don't think it's defensible anymore, cutting apart the Bill of Rights, because most people, when they extol the Constitution, talk about the Bill of Rights. And there's a lot of good stuff in the Bill of Rights. The only problem is the Bill of Rights had to be driven in by revolutionary white males with property who said, we're not going to ratify the Constitution unless you have the Bill of Rights on. So the text of the Constitution needs to be changed, needs to be overhauled, needs to be rewritten. And I don't think it's defensible anymore to say that it doesn't need that. I think what we're seeing with this amendment through the Community Rights Network, the work of the community rights across the United States, is the first step towards opening a broader window for communities to pass laws and actually to control their own fates. I think eventually it's going to have to come back around after we have 10,000 communities who are exercising that right to pass laws at the local level, to then come back around to end up in a rewrite of the federal Constitution. Because a lot of people are horrified with, you're going to open up the federal Constitution? We don't have the power to control what happens. All the good stuff is going to get stripped out. And then one guy said, well, without a movement, of course. Well, of course. You have to build a movement that blueprints what the new Constitution looks like. Otherwise, you're not powerful enough to hold that frame, and you're going to lose it. And so this is about building from the bottom up, blueprinting what that change looks like, and eventually ending up in a place where there are enough people to force a rewrite of the U.S. Constitution.
I know that in the past I've heard you say that this whole transformation is not going to occur from anyone important.
Yes.
That the judges won't touch it, the lawyers won't touch it, the professors of law won't touch it, the legislatures won't touch it. Nobody will touch it. It's going to have to come from the people.
Yes.
That we're on our own.
It's like in the 1840s, nobody would touch abolition of slavery. In the rewritten history that we have, you would think that it was such a popular cause that everybody just flocked to the banner. Well, no, it was 12 people in the 1840s, and abolition was a dirty word. People got beaten up for having conversations about it. Those 12 people found a way to take their cultural experience, their understanding of how the law should operate and how it did operate, and actually expand that out to a movement that eventually resulted in changes to the federal Constitution.
Okay, so that leads us to the definition of a movement.
Right.
So a lot of us are under the illusion that we actually have an, quote, environmental movement. But what we see is that there has been no fundamental structural change in the legal system to give the environment rights to exist and flourish.
Right.
except in in the cases of our community bills of rights.
Yes. So I think there are two parts to that. Number one is that we've never had an environmental movement in this country because it's been property based. So if you have a deed to a piece of property, it carries with it today the legal authority to destroy the ecosystems on that piece of property. I can buy an acre outside of Boulder, if I could afford it, and take that acre and cement the whole thing into a small landing strip for my drone that I have a permit to operate. So I want to just concrete the whole thing. There's nothing in the law that stops me from doing that, unless, of course, there's an endangered species or a wetland, one of these rare circumstances. But my deed carries with it the legal authority to destroy the ecosystems on that piece of property. Yeah. And we've tried to build an environmental movement around that to validate that property rights in environmental issues are okay, that system's okay. They're basically saying it's okay that we have that kind of system in which you can the more money you have, the more land you own, the more ecosystems you can destroy. And we tried to build a movement around that. But when you build a movement around that, you're talking about trying to regulate uses, and you're automatically on the defensive. Right. Because there's a property owner and property owned, and then you're trying to regulate the use of that property, but you're on the defensive automatically. And part of the problem for that is that we've never had a rights-based system of environmental protection in the United States, which shifts from property-based to rights-based, which means that ecosystems have rights of their own. Right. And 5 years ago, when I used to go out and give talks on rights of nature, people used to think it's crazy. And a lot of people still think it's crazy. But since that time, the country of Ecuador has shifted from being a property-based environmental protection system to a rights-based system, and in fact has had several legal cases now of enforcement of those rights of nature.
Awesome.
In which the plaintiff has been the ecosystem itself. So in the first case, the ecosystem was a river. So it was a river bringing suit to enforce its own rights. And that's kind of hard to get our brains around sometimes. But that is the future of environmental law. If environmental law and environmental groups have any interest in actually being effective, and for 40 years, environmental organizations and the environmental quote-unquote movement in this country have been very ineffective because, of course, today by almost every major environmental statistic, things are worse now than they were 40 years ago when the major environmental laws were in place. In private conversations with environmental lawyers, you get to that. They'll admit that it's ineffective and that we're at a point where we need to change gears, but nobody really knows how in other circles. And so I think the next great big frontier is recognizing that nature has enforceable rights of its own. And we're working with folks in Nepal and Mexico and other countries to try to replicate what's happened in Ecuador. So the rights of nature stuff is extremely important because I think without it, we're kind of screwed, and we're back in the same place about trying to regulate property use without actually getting to the issue of whether nature should have rights or not. And in many ways, we return back to the 1840s when African Americans were treated as things under the law, not as persons, and they were treated as property, and women, of course, up until the early 1900s were property or things as well. And this gets to your second point, which is how do you define what a movement is and what it isn't? A movement isn't just enough people getting together saying, hey, this is a good idea.
Right.
Movements are about taking things that are treated as things under the law and transforming those things into rights-bearing entities. So the abolitionists took African American slaves from being things to being persons. And under the U.S. Constitution, you're either a thing or you're a person. If you're a person, you have rights. If you're a thing, you have no rights. And in fact, your rights are derivative through other people. Like if you're a slave, your rights are derivative through the slave owner. If you're a woman and you're a thing, your rights are derivative through your husband or the oldest male within the family unit.
Right.
And so movements are about transforming things and property into being rights-bearing entities. Today, our communities, like Boulder, the Boulder Municipal Corporation, the Boulder municipality is a thing under the law. You are not even recognized as having rights vis-a-vis your own local government, your own local municipal corporation. You're a thing. Your community is a thing to be used. So the state can mandate certain things into the community. The corporation can mandate things into the community because you have no countervailing rights. Right. You have no countervailing force to push up against. And if there's one thing that's true in this system, it's, if you can take it, you do. So the corporations take it and the state takes it because there's nothing pushing back on them. And so this movement is about transforming the thing that is currently treated as the municipal corporation into a rights-bearing entity, or more appropriately and precisely, rights-bearing entities being rights-bearing people who come together collectively to exercise rights as a community. So, and that's a lot different than a rights accruing to a municipal corporation. Those are two different things. And so what we're talking about is taking a thing and transforming it into a rights-bearing entity. That's our definition of a movement. And what I think needs to happen is that movement has to go wide scale, has to go prime time. It has to elevate and rise to a point where enough people are refusing to obey the system of law that they're forcing that to happen in 10,000 different places. That's the only thing that forces a crisis to happen. A crisis between the state and the local, a crisis between the federal and the local, eventually a crisis between the federal and the state. All that stuff has to burn. I mean, there has to be a confrontation and picked fights between those layers. It's exactly what the abolitionists and the suffragists did, because they said, look, this is a crisis. And a lot of people said, we don't live in a crisis. Slavery is good. People like being slaves. It works. It's an economic production system. And so what those groups systematically did was they picked very scripted fights to actually illustrate to people that we are in a crisis, that the law is not commensurate to the changes that needed to be run. And so I think today we're in that same situation. The Lafayette stuff, even the Fort Collins and the Longmont laws, at least they were people standing up. They did so under an imperfect, shoddily constructed construct, but that a lot of people don't stand up at all. And so just the fact that people stand up is a good thing.
Right.
You're drawing the confrontation, you're forcing the system to have a cost of some kind. And I think that's good. We just need to get a lot more advanced about how those confrontations take place.
Well, thank you for that. Yeah, this is more than community rights 2.0, I think.
Maybe 4.0.
Maybe 4.0.
Right.
And, if you would like help understanding some of these concepts, you can go to our websites. The Community Environmental Legal Defense Fund we call it CELDF, CELDF.org. And there you will see a lot of information about community rights organizing. And go to our East Boulder County United website. That's our local one here. For Lafayette and for East Boulder County, it's eastbocounited.org. You can see what Lafayette has done. You can see the Lafayette Community Bill of Rights. And then our state website is COCERN, Colorado Community Rights Network, COCRN.org. And then go to the various states. You can get there by going to the National Community Rights website. It's nationalcommunityrightsnetwork.org, and see what's going on around the country. And it's been a real privilege to have you here, Thomas. Is there anything you'd like to leave us with before you go?
Just that this tour that I'm doing over the next couple of days is called Time for a Colorado Revolt, and the words are very carefully chosen. It's time to act and time to not be so obedient when we're told that we can't. And that's where real movements start. So that's what has to happen.
Thank you so much.
Thanks for having me.